Committee is resumed for further consideration of the Search and Surveillance Bill and the Crown Pastoral Land Rent for Pastoral Leases Amendment Bill. Members, before the dinner break we were debating Part 1 of the Search and Surveillance Bill, and the Honourable David Parker had the call. He's got just under 30 seconds remaining.
Thank you, Mr. Chairman.
You're seeking a call.
Mr. Chairman.
Honourable David Parker.
Thank you, Mr. Chairman. I had just turned to the issue of the Serious Fraud Office just before the dinner break, and I was responding to one of the claims made by Mr. McIndoe from National that this was standardising, Mr. Chairman.
Honourable David Parker.
Thank you, Mr. Chairman. That this law was standardising rules relating to different Crown agencies, not Crown agencies, just different arms of the state, whether it's the Pig Industry Authority, I think is one of those listed, or the Housing Corporation, or the many statutory bodies that are listed at the back part of this schedule, where the different powers of the Meat Industry Board and the Health Practitioners Competence Assurance Board are allocated the different powers that arise from this Act, and they don't all get the same powers, but one way or another all of the powers of these various arms of the state are regulated through this legislation. And of course the most important of all of those for most investigative processes is the police, but excluded from this is the Serious Fraud Office. Now the reason that Part 1 has got an amendment in my name to add the SFO Director into the interpretation section is that we need to have the Serious Fraud Office brought into this. As my friend Charles Chevelle has said, this was blocked by government members and by the then Minister refusing to cooperate through alternative processes that could have fixed this under old standing orders, which said that a matter was outside of the scope of a bill, even if it was within the scope of the subject matter, if the Act that was to be amended by the bill wasn't listed in the Act, in the bill that was before us. We couldn't have an amendment which affected that other Act that isn't listed, even though it was within the scope of what we're talking about. Now, that silly rule in standing orders has actually not been carried forward into the standing orders for this, and that's a good change, and I thank members from all sides of the House for cooperating in that change in standing orders. And what it effectively means is we can now fix it in this bill. We actually don't need to have any special process other than a vote in this House to say that let's fix the Serious Fraud Office powers at the same time, because it's within scope. Now, why should we be concerned about this? Media freedoms are absolutely essential to the health of democracy. Media freedoms are necessary to maintain public institutions. Countries that don't have media freedoms have more corruption, they have less public confidence in public institutions, they have poorer outcomes, they have poorer societies, and they have more human rights abuses. So we must be very, very careful to protect media freedoms. In New Zealand, there is one glaring exception to pretty good laws in terms of media freedoms, and that relates to the Serious Fraud Office. The Serious Fraud Office can issue a production order or an examination order against the press from their own office. They don't need any judicial oversight, which was one of the things that was referred to by Cam Calder in his contribution as saying why people should have confidence in this law, that people had to have judicial oversight to get a warrant. The Serious Fraud Office don't have to. They've got two routes. They can go a warranted route or they can go a production order, examination order route. And what do they do in practice? They take the easy route and they don't get a warrant. So by internal administrative act of the Serious Fraud Office, they can tell the media that they want them to hand over their documents. That's what a production order does. Never happened since the Serious Fraud Office legislation was passed until 2 years ago under this government, when the Serious Fraud Office issued a production order against the National Business Review, ordering them to produce their documents in respect of the National Business Review inquiry into the failure of South Canterbury Finance. The National Business Review then are faced with this situation. To refuse to comply with that production order, they are in breach of the law and committing a criminal offence. They are subject to fines plus other criminal penalties. Both the journalists if they're the person that gets the production order and the owner of the National Business Review. So they immediately have put it in breach of the law, and what do they want to do? They just want to protect their source. Why should they protect their source? Because if the sources of the media are not protected, they don't talk to the media. And there's a public interest in the media being able to report things that are adverse to governments or to politicians. And we might not like the times where we think their criticisms are wrong of us, or that where we think they're a bit superficial, or where they're a bit hurtful. We might not like it, but we must always defend the right of the media to do that, because that is what protects the health of our democratic institutions. Rooting out corruption, rooting out mistakes where they're found, and in the case of the National Business Review, there were hundreds of millions of dollars of wasted money.
Simon Bridges.
I hope a reasonably short call just to